Welcome back to Property Play. I'm your host, Elena Saradidis, and I'm with Jonathan Hacohen once again, the chosen lawyer and author of The Chosen Life.
The 6 commandments of the chosen life. Thank you.
I like to shorten it a little bit, but it's okay. Today we're talking all things cohabitation. We're just coming off of Family Day and Valentine's Day.
And Family Real Estate Assessment Day. All these holidays.
Our new holiday that we've just created. And we're going to talk about what happens when you decide to move in with your significant other and you own the property and they do not.
Yes. If I had $1, a loonie for those of you watching in the US, but if I had a loonie for every time somebody calls me up and says, my son or daughter are buying their first place, we're helping them with the down payment, and they want their significant other to come and live with them in the property, how do we protect our down payment? How do we protect them from making a claim to the property? Help us.
Okay.
So first thing I tell folks when they give me those nice questions is this much. I am a real estate corporate lawyer. I also do wills and estates. Not do family law. I've never done family law. I will never do family law. When you have an issue for family law, the person you call is?
A family lawyer.
Family lawyer. Exactly. So it's time to, so this is the most romantic, unromantic. Okay. So in a couple's existence, we just came off Valentine's Day, Love Day. We're going to talk about the 2 most unromantic things a couple can do together. Number 1, prepare wills, power of attorneys together. Number 2 is make a cohabitation agreement. It is so unsexy. It feels so not loving, but we all go in with great intentions and love and hope. But there's times where things don't always work out well. When everybody is in a really good mood and on side together, it's nice to get things on paper and squared away so that if things fall apart, then we already have an agreement in place on how we're going to deal with it. When things break down and we do not have an agreement on how to deal with it, that is not the best time to negotiate and figure things out. So when I tell people before you move in together, you've talked about it, you're going to buy the property, you want to bring your significant other, you go to a family law lawyer, discuss this scenario, have them draft a very unromantic, unloving agreement, but squared away with what your expectation is if the relationship falls apart, who does what, who owes anybody what, how does it work for property-wise. Then you have to take that agreement, very important, send it with your significant other to their own family law lawyer. You're not using the same lawyer together, and you're not printing it off the internet, signing it together with no witnesses, no family law lawyers, because that isn't worth the paper it's written on. Why? So somebody goes to a family law lawyer, has the agreement prepared, hands it over to significant other. Significant other says, sure, I'll just sign right now. Signs it, hands it back to the person. I'm done. Relationship falls apart. Significant other goes to court. The first thing they're going to say is, I didn't understand that agreement. I never had legal advice. I was taken advantage of. I didn't understand. I signed under force. I shouldn't have to adhere to this agreement, and they'll be correct.
Now, the question I get asked all the time, and I'm sure you'll have the answer for me, is, Elena, but what if I make them sign a lease? I know you know the answer. You've told me the answer to this before.
Okay. So you get the person to sign a lease. Same scenario where the parents put down the down payment and the parents make you sign a mortgage and they're saying, you owe me this money because I lent you the money. Fine. Relationship breaks down. You come to court now. And the court, the person who got the lease and the mortgage says to the judge, look, they signed a lease. They're a tenant. I signed a mortgage. I owe this money back to my parents. Judge is going to ask 2 questions. So you were in a relationship with this person, right? You're sleeping with them. You go on vacation with them. You're building a life together. You got engaged and you made them sign a lease. Right. That doesn't smell right to me. And your parents lent you the money as a mortgage. Huh, okay. Did you pay back your parents? Have you been making any monthly payments? No. They gave you money 5 years ago, 10 years ago, and you never made a single payment. Sounds like a gift to me. So you can label it whatever you want. You can call it a tenancy. You can call it a mortgage. It don't matter. It has to pass the smell test. And it's what a reasonable person would consider. What a reasonable person would say for the lease. Let's just take the lease right now. Did you put it on the MLS? Did you put an ad in the paper? Did you find somebody off the street? Did you do a credit check? Did you sign a lease with them? Did you hand them over the keys? Not, did I date the person? Did I get engaged to the person? That first person sounds like a lease. Second person doesn't sound like a lease. So be very, very careful with it. Now, there are times where you have family members. Let's say, for example, I saw one. We do a real life example?
Yep.
Real life example. Person buys a condo, says to their brother, hey, brother, I want to rent you this condo. You've been looking for spots. I just bought a condo. Why don't you rent it with your significant other? Instead of me going to get another tenant, I might as well put you. I trust you. Great. They sign a lease. Brother is a tenant with a significant other, pays monthly rental checks. The brother that owns it pays the mortgage, pays the property taxes, pays the common expenses. That's a lease. That fits everything into a lease. But if the first brother is the one, the tenant is the one that actually bought the whole thing and put the real down payment, now we're getting into murky waters. So what I tell people is if you're in this kind of scenario, stop before you make these arrangements. Talk to a family law lawyer, talk to a real estate lawyer, talk to your accountant. We have all sorts of planning that's needed here. Don't put yourself in this scenario and then come back to the professional and say, help, I think I screwed up. Let's get it set up right as the arrangement from the beginning.
So I had this case a while back, and I believe that we actually share the client. So when they first came to me, they were getting gifted money from Bank of Mom and Dad. Yeah. And Bank of Mom and Dad said, we want to make sure that the money that we gifted is always my kids' money. So if, for example, this individual falls in love, moves in with their partner in the future, how do we secure the money that we gave her in the future? What would you do?
So, and we're assuming that they're not married yet?
They're not married. They don't even have a partner yet. But they want to make sure that whatever money was given, whatever money they would inherit, is basically always secure for that individual.
Well, we're going to take it on a case-by-case basis because a lot of variables can change the whole circumstances. For example, the parents could leave a gift in the will. So they haven't given the gift yet. Then when they're passed, let's say mom passes, gives a gift to her daughter. And in the will, it stipulates that this is a gift so that if you in the future get married and split up from your spouse, this should be considered a gift through the will. So you shouldn't have to give up half of it.
And is that still the case if they've already bought with the money?
So if they've already gone and bought, so here's one of the items. Let's say, for example, a person received the inheritance, but then they went off and got married.
Yeah.
Didn't sign any kind of agreement, no cohabitation agreement, no marriage contract, nothing. Took the money from the gift, put it into the home, and now own the matrimonial home either outright or 50-50 with their partner. They can consider that inheritance now part of the matrimonial home. If there's a split in the couple, it's going to be 50-50.
But what happens if it's before you're even together, before you're even a couple, before you're even married, before you're even engaged, you don't even know the partner yet. Your parent gave you some gift money. You bought a property with that gift money. The parents want to secure the money. How do you secure it?
There's an expression, Elena. You can't have your cake and eat it too. You know why? Because cake is delicious and cake is right there. And you want to have the cake, but then you eat the cake. And if you eat the cake doesn't exist anymore. This is no different than this arrangement. You have to make a choice. If you're the parents, I'm talking to mom and dad right now. You have a choice. You're either going to choose, is it a gift or is it a loan? Can't have it both ways. Once it's the gift is given, say goodbye to the gift. Now the kids have to decide how to secure it into the future. If you're the parents and you gave the money and you're saying, I want to make sure I secure this, well, then we have a choice in life. Then we decide, okay, do we want to write an IOU? Where the kids will actually sign an IOU, a promissory note, as we call it in legal terms, saying that this money was given to me by my parents. I confirm that I owe this money back to them. Parents may even secure a mortgage against the property as a second mortgage or a first mortgage if there was no mortgage to begin with, and may in fact make the child make payments towards the mortgage. But in the future in their will, they may say, hey, I'm giving you back all of it and it's yours at the end. But they have to think holistically what the actual game plan is here. So I would say no to outright gift if the parents want to keep their control on.
You know, I absolutely love asking you hypothetical questions.
We live for this.
So I'm going to ask you,
yes.
Would something like this work?
Please.
Let's say, for example, I get gifted the money. I buy a property. I decide that, it is an IOU. I tell my parents, we owe you the money one day.
Yes.
They put it like they register that, the IOU against the property.
So they actually register a mortgage, sure. Okay.
But we don't have to pay it back until after it actually sells. Okay?
Fine.
So if we're ever forced to sell the property, that money has to be gifted back.
Yes.
Now, hypothetically, would I have to make payments on that?
You don't have to necessarily, but it's clear then what you found a little loophole, so to speak, where it's clear that, hey, I'm being a nice person here, not going to make you make payments, but when you do go to sell the property, I expect this to be repaid back.
Now, if hypothetically, I know you're not a family law lawyer.
And I'm not giving family advice, but go ahead.
But if, for example, this happened,
yes,
then the parents passed, and now you own the property still, your significant other has moved in, it goes sideways or it doesn't go sideways or something happens and the property sells. Now that IOU, where does that money go to? Does it go to their estate?
So this is where a couple items come up here.
Okay.
Number one, if I'm talking to parents and I'm the parents' lawyer as the wills estates lawyer, I would tell them, you made me aware of this IOU promissory note out there. I would deal with it in the will and make it very clear. Is it forgiven or does it become part of the estate? If they're silent about it, then it's going to be a money that's owed to the estate. It's actually still remaining a debt.
Okay.
Or they may put as forgiven. Then the child, who is now an adult, has this IOU promissory note out there and with the property. They meet a wonderful person. They start dating them. They move in together. It's now a full-blown relationship. Maybe they're going to get married, whatever be it. I would have that significant other go to their own family law lawyer with a cohabitation agreement. And the cohabitation agreement makes mention of the promissory note and IOU. The significant other acknowledges that's out there and that's a debt owing to the parents. See what we've done here? So we need that reaffirmation if possible. It'd be much better to have it if possible.
And then if, for example, the estate had it written out like it was inheritance to the daughter, then can't we save the money? Like, didn't we protect the money that way?
It's better.
It's better. It's not a sure thing.
Never anything's a sure thing, but it's better. And something I want to tell you one thing right now that's going to blow your mind. Are you ready?
I'm ready.
People, the number one mistake people make with these items is they're very fixated on relationship, significant other, spouse, fiance, girlfriend, boyfriend. Anybody can be in a cohabitation. So let's say you have best friends from university and they buy a property together, siblings living together. Anybody that's living together that could have an interest, that put in money, we have to work on an arrangement. All of them can put an agreement together, whether it's a cohabitation agreement, a joint venture agreement. As soon as you have more than one party and more than one invested money into it and more than one is living in the property, any of these kind of scenarios, we should put a contract in writing to be clear who put in what, who's responsible for what, who owns what, and if the things go sideways, how do we deal with it? These are all prime relationships that people do. Like, I've had so many best friends, Elena, that thought, I can't afford a property on my own. I'm going to bring in my best friend. We're going to live there together, but I have more money than them. So I'm going to put in 80%. They're going to put in 20%, but we're equally responsible for the expenses. I end up paying 100% of the expenses. They paid nothing. Now it's time to sell the property, and my friend wants 50-50.
I feel like we talked about this, and I can't remember if we talked about it on this podcast or we talked about it on your podcast.
We did talk about it at some point.
We did talk about this.
But it still comes up all the time, and people still make the same mistake of not putting the relationship in writing and then coming back after the fact and saying, the relationship is breaking down, now let's negotiate it.
These are conversations you should have with your partners, your friends, your whatever, if you're planning to own a property together, not just cohabitation agreements. Now we're talking about how do we assign the asset? What happens if you pay more mortgage payments? If I pay more mortgage payments? If, for example, like maintenance is required on the property, how does it work? If you have to loan me extra money 1 month, how does ownership work? All of this can be pre-discussed with the lawyer ahead of time. There are terms and conditions that you can put in the agreement ahead of time. You can put in stuff like what happens if you make an extra mortgage payment and they don't. Does that now change if we own it 50-50 to now I own it 60 and you own it 40?
I take over your portion of the debt and I own more of the property. Exactly. Or I can force you to sell it to me, or I could force us to sell it to a third party, whatever be it. So much out. Like, it's funny, Elena, if you and I were going to go and open up a restaurant together, we're best friends. We should go open a business together. That's the greatest idea ever. Let's do something that we have no idea about. Let's go open up a restaurant together. Of course, we would go and go to respective lawyers and go and have our agreement drafted as far as our responsibilities and our rights in this restaurant business. We would do the same thing whether we own a restaurant or own a piece of real estate. I know it takes a lot of love and affection out of the equation, but again, before people even enter into the venture, if they have this agreement ready going into it, let's say you have two siblings and they write out the agreement, okay, what are we each putting in? What are we responsible? What are the worst case scenarios? What if we have to sell? How does one buy out the other? Life will be so much easier if they have it on paper from day one.
Right.
But it's out there. And we're going to see this more and more and more as real estate prices are rising. People's incomes are not rising by the same effect. Who are saying, I want to get into the real estate game. I can't afford to do it on my own. I'm 25, 27. Instead of me waiting till I'm 40, I'm going to go in with two siblings. I'm going to go in with a sibling and a friend. And the three of us are going to buy it together. It's a 3-bedroom. We'll each get our own room. These are actually very smart investments to get into the market as long as you paper it correctly.
And I can tell you this, and I'm sure you do too. I have joint ventures with other people. Like, it was needed at the time. I wanted to buy something specific. It was in the right area. Maybe I didn't have all the cash up front at that moment, which is okay. But I'm like, okay, we'll partner it. Okay, we'll create a corporation and we'll own it in the corp. And everyone will have shares of the corporation. Okay, we'll do X, Y, Z. What is everyone's responsibilities? I'm a real estate agent. So am I the one taking care of the lease agreements? If I'm going to list it on MLS, are we still paying realtor fees? How are we going to structure that? All of that was pre-discussed.
Who's going to manage the property? Is there going to be property management fees? There's so much that can go into it.
And like, if I'm going to do all of that, are you going to put in more money? And then I put sweat equity.
Right.
So like, all of these things can be discussed and all of them should be discussed before you even move in. But like prenups and postnups, no one thinks they need it until it actually happens.
And it's happened. I've seen this. What happens when you have two people own real estate together? One person passes away. They don't have an agreement together. The estate takes over the other interest. And that first person does not want to be in business with the estate or the respective beneficiary. That's a giant problem. But if somebody gets disabled, lose their job, loses their income, now what are we going to do? Again, all these kind of scenarios can be worked out in an agreement ahead of time. Just think of it. It's a venture. Like when you're buying real estate as in a business sense, the venture, we're doing it joint venture.
But I'm going to say this, and I'm going to ask you for the definition of both. Joint tenancy or tenants in common. Because when you're going to buy a property with someone else, what's the right way to go? And what do each of those mean?
So, great question. Very often people don't think about this and just go, yeah, that's fine. Don't worry about it. Definitely worry about it. I need to know what the people's intentions are. And to be clear, what you decide today can be very different what you decide into the future. I'm going to take the example. Two sisters, single, non-relationship, okay? Both are fully single. I tell them, you're going to buy this property together. You're going to live together in this property. Your loving sister, your twins, your whatever. What happens if one of you passes away? Oh, the other sister's getting it 1,000%. Okay, joint tenancy makes sense. Joint tenancy, own the property jointly. Somebody passes away, property automatically goes to remainder joint tenant. So if it's two people, the second person gets it automatically. All you have to do is get the death certificate, register survivorship. This person now owns it outright. You don't probate. You're not paying probate tax. That's the idea. But let's say those sisters did it that way. Now, 4 years later, each of them are in a relationship. One's engaged. The other one goes off to Las Vegas, gets married spur of the moment. And I come back to the sisters again. You bought the property as joint tenants. You're now living in matrimonial heaven with each of your respective significant others. Something happens to one of you, who's to get the property? Well, I definitely want my spouse to get it. I want my boyfriend to get it.
Or my kids.
Or in future, my kids, perhaps. Because one of the things is, what we decide today, we forget that things can change circumstances to the future. We could have a spouse pass, but we have, let's say, 2 or 3 children. We want our children to receive our inheritance. Exactly. But if we hold it as joint tenants, there's going to be an issue here. Let's say those sisters left the property as joint tenants, and one passes away, and that one was married. That husband of the deceased can come and say, well, I was living in the property with them. This was our matrimonial property, that 50%. That 50% should not pass to the sister because I have a claim now as the family member, as the spouse. So even though it's joint tenancy, I can make a family law claim for that interest. But even before that, that sister may say, I want to cut the joint tenancy. I want to be tenants in common. We each have our respective shares, and our share only goes to the will or estate. It does not flow through to the other owner, simply because I have a spouse, I have children, I want to make sure they get it, not the other owner. Yeah. So this is where you have the hard conversation with the lawyer at the beginning to make sure whatever, when a person first signs their agreement, Elena, they don't have to make the decision in that instance. We can make joint tenancy in common right up until the day of closing. I've had couples that were engaged and wanted joint tenancy, and then they came the day of closing. They said, you know what? We already made our prenup, and I don't want it to flow to the person. We don't know if we're going to get married or not for sure. Tenancy in common. So this is where those circumstances can happen.
I have both. It depends on the property, it depends on the situation, it depends on what we're doing at the time. Like all of the above on like what happens and how it happens. I know a lot of my clients that have both of those situations flowing, but every one of them also knows at any time that you're thinking about changing it, you should go ahead and change it.
If I could just throw now the biggest legal advice I can give for people that is not legal advice, but the things to think about is this. I get asked all the time by parents, I'm worried that when I pass, my kids are going to have to pay tax. I just want to add my kids to title now so we can avoid taxes. Is that a good way to go? I tell people very often, the accountants have told me, no, go speak to your accountant first. Why? Because you add your child to your house. Let's say you have mom and she has her child to the property and now has a title with the child as joint tenants, but the child doesn't live in the property. Child has her own place, and it's been like this for like 10, 20 years, let's say, on title. Mom passes. Guess what? We have an issue here when you go to sell the property, because if it would have been just mom's property, it would have been her primary residence. Life is very easy. Child on title that it's not their primary residence, we may have a capital gains issue. So sometimes you'll save probate of 1.5%, and now you're paying 50% tax. So think about it. So that's where I'm telling people, when you're going to do holistic financial planning, don't just go add people the title thing you're to save tax. You may want to pay the tax at the end, save tax currently. So speak with your accountant on that. It's very important in real estate to have big financial planning.
So because you're mentioning this, I think it would be a great thing to bring an accountant and you back next week, and we talk all things how to structure your corporations, how to structure how you pass down properties with them. Sounds like a plan?
Bring the accountant? Love to. Done.
Perfect. Once again, thank you so much, Jonathan Hacohen, the chosen lawyer, for joining us today. It's Elena Saradidis with Property Plan. If you like content like this, make sure to like, follow, and subscribe.